With apologies for keeping you waiting. I know I said 5 past, but something cropped up. Yes.
Thank you, my lords. The appellant seeks to set aside the judgment on the grounds that it is either A, distinguishable from the Sanix Ace and the Baltic Strait, and the grounds for saying it is distinguishable are one, what I will call the construction argument, namely that the wording of the assignment was allegedly limited to certain rights. This feeds into the representative action points that my learned friend was making earlier, namely that there's some other type of title to sue that could have been assigned but wasn't assigned. Two, that the sales agreement was on a CIF basis, with the quantity determined at load port by way of certificates, meaning that Oilex couldn't have maintained or would not have been successful in any claim, at least insofar as it is brought under English law within England. And three, that the payment predated the written assignment. Now, there was some discussion on that earlier today. I won't go into that point in any great depth. And then B, my learned friend also argues that...
sorry, I've got confused.
Apologies.
3 were 3 grounds of distinction.
Yes.
Just to make them again, in headline terms.
Construction argument.
Yeah.
I.e. the assignment construction.
Yeah.
The CIF argument.
Yeah, got it, okay.
And then the timing argument.
Yeah, got it, thanks.
And then B, the bad law argument, as I would call it, namely that the Sanix Ace and or Baltic Strait are incorrect, and that the EDNF and or Swinson has somehow limited the test for collateral so that the facts of this
he doesn't
case do not
say
satisfy.
they're wrong. He says that Baltic Straits is wrong in one respect. But he says that they are only limited to certain situations, of which this is not one.
Indeed, those were the oral submissions. The skeleton argued that the Sanix Ace needed re-examining in light of EDNF and...
Well, I noticed that, and that's why I asked him whether he said it was wrong, but he seemed to have survived that.
I'm happy to proceed on that basis.
Well, the critical point seems to be that the arrangement by which the payment was made was not something linked to or arising out of the sale contract, contrary to what the judge said. As I understood Mr. Seamark's submissions, that was really the foundation of much of what he said.
I'm happy to deal with that point first, if it would assist.
Probably would.
Well,
as noted by the trial judge at paragraph 11 of her reasons for rejecting the permission to appeal, this argument, i.e. that there's a lack of connection between the sales contract and the settlement sum, shall we say, suggests that the principle applicable requires the holder of the bill of lading to establish a legal entitlement to any sum settled under the sales contract, which is contrary to the approach in the Baltic Strait. As the trial judge went on to explain, in that same paragraph, this is partially a question of fact and depending on the factual finding that the settlement arose under the sale contract and was linked to the rights under that contract. That was a factual conclusion because the relationship between the first claimant and Oilex was based on the sale contract only. There was no other basis for the payment to be made to Oilex. That's C/6/75 if it assists.
that's rather expanding on what she said in the actual judgment. To what extent are we allowed to, or to what extent can the judge supplement her judgment by what she says?
I would suggest that insofar as there's ambiguity in how the judgment is written, she is entitled to explain the basis on which she made her findings.
Well, I think the point that's been put to you is that it's an expansion of the findings, not just an explanation as to what was found.
Well, my suggestion would be that is the underlying basis of the findings, whether or not it had been expressed in those terms within the written judgment. But in any event, the idea that in order to establish that a settlement is collateral as a payment under a separate contract, you have to somehow investigate whether or not the party claiming under that contract, and we'll come on to that in a moment, the party claiming under that contract would have been successful in their claim, is, in my suggestion, not indicated in the authorities. Nor if one was going to indulge in such a apologies.
When you say whether the party would have been successful in their claim,
Yeah.
where is the evidence that there was even a claim?
Well, that was the point I was going to come on to. The evidence of the claim is or the findings of fact in support of the claim is at paragraphs 23 of the judgment, which is C/5/58. Where the trial judge says there was no direct evidence from the first claimant or Oilex to explain their actions, i.e. we didn't produce any witness evidence or anything of such.
So which paragraph?
23, my lord.
23, yes, thank you.
But one of the survey reports indicated that Oilex had rejected the cargo taken to El Sharouk. The contemporaneous correspondence suggested that the first claimant had arranged and paid for the trucks and warehousing, and the survey costs claimed had been paid by the second claimant as its insurer. A similar point is then made in relation to the salvage sale on the 24th of September, where it states 3 weeks had passed since the damaged cargo had been discovered.
So which paragraph?
That's paragraph 85, subparagraph B. And that's page 70.
Paragraph 85.
Page 70 of the court bundle, if that assists.
Thank you.
A similar finding, as I say, was made. 3 weeks had passed since damage to the cargo had been discovered. Oilex appeared to have rejected the cargo. So those are the two findings which I say show that there was a dispute. Beyond that, coming back to a point that was made earlier by your lordships, there's no other basis in which the seller would have engaged in this behaviour other than the settlement of a commercial dispute. Indeed, my learned friend even said in his oral submissions that his suggested reason was to get rid of the impasse, to sort the thing out. Well, that, to my suggestion, is exactly what a settlement of a dispute is. I'll come on to the only other possible explanation of the event.
Well, what is the dispute? Sorry, I mean, just to be... Sorry.
But the dispute is that damaged cargo had been delivered. Now, the BNCIF on loading certificates, final loading certificates, I accept that it's very unlikely that that claim would be successful. However, there certainly could be
that claim. What is the claim?
The claim for damages in respect of damaged cargo being delivered. And I'm not going to take this cargo, or I want my money back from this cargo.
This is
It's the same dispute that was raised in the Baltic Strait.
So the buyer says to the seller, what? What's the claim? What's the breach of contract claim?
Well, that would be a potentially implied term of the warranty that the cargo can survive until a reasonable form of transport. Now, my learned friend would certainly argue, well, wait a second, would that have survived the inclusion of the specific specification within the contract, or the clause that they don't warrant beyond?
So this is a contract, forgive me, this is a contract, risk passes when?
Risk passes on loading.
Right. So, and that's certified?
Risk passes on loading in the CIF contract, yes, and it's certified.
So where's the scope for the claim by the buyer against the seller?
I think we're conflating, or at least I'm not explaining the two distinct points.
Yeah, you have to go. Somebody once said to me, a much more senior judge once said to me as advocate, you have to go at the pace of the slowest ship in the convoy.
Point 1 is whether or not a claim was asserted. Point 2 is whether that claim could have been successful. Point 1, whether... Apologies, go ahead.
Yes, I think you've more or less accepted, haven't you, that there's no evidence the claim was asserted? Or not, maybe you're about to.
I say that the findings of the judge was that there was a purported rejection.
So you say that a rejection necessarily implies a claim by the rejector, who is said to be Oilex, against the
seller.
I see.
And I say that the existence of that dispute is by far the most logical explanation for the steps we then see taken.
I mean, the highest it's put is that one of the survey reports indicated that Oilex had rejected the cargo. I mean, we haven't seen that, I don't know.
No. Which is the only direct evidence on the point.
Well, it's not that.
Well, the only evidence on the point. Apologies.
The judge says there's no direct evidence to explain what happened.
However, one must look at this logically. What other commercial explanation would there be for Ameropa engaging in assisting Oilex in disposing of the cargo and for paying this, what we call the settlement sum, to Ameropa? The only other explanation would be it's a benevolent gift. That would be the only other explanation. If there's no legal obligation or threat of legal obligation to...
Well, they have an existing relationship, don't they?
Which, in my submission, if there's goodwill, that would come within the realms of, as Swinson discusses, benevolent gift given by family.
We don't actually know there's an existing relationship, do we?
We don't have any direct fact on that.
Well, okay, I mean, the amount is done by way of a credit note.
Yes.
Which suggests, it doesn't actually suggest that there's necessarily an existing relationship.
Yes, there's an anticipated future relationship,
at very least.
Yes.
I suppose we also have to bear in mind that at the date when all this was happening, the owners had not admitted liability, and the possibility arose that the damage was not, or would be alleged to be, not caused by the heating during the voyage, but by the pre-shipment condition of the cargo. That would still leave the buyers in making a claim under the sale contract to get over the final quality and condition certificate, but these things have been known, and it is also known for cargo to heat during the voyage because of its condition on shipment, e.g. it's too moist or something like that. And so all of these things were potentially in play. Whether they were ever articulated is perhaps another matter, but were potentially in play at the time when people were having to decide what to do.
Indeed, my lord.
It's legitimate also to feed into the commercial situation. But one doesn't know in what forum a claim would have been brought. There's an arbitration clause, but query if proceedings were brought, say, in the courts in Egypt, that would be respected. Maybe Ameropa didn't have any assets in Egypt, I don't know. But
indeed, my lord, that's one of the points I make in my skeleton is it rather assumes that it would be brought under English law and in England, which, as anyone involved in international transportation of goods disputes knows, often does not happen. Coming back to your point, my lord, that's the exact reason I raised the implied warranty of being suitable for a reasonable voyage, because if it was self-heating, etc., those kind of arguments would be made. And coming to the point of the owners had not at that stage admitted liability. Indeed, they didn't admit liability in their original defence. In their original defence, if I can get the paragraph. In the original defence, it was alleged that the damage had arisen through inter alia inherent vice.
Where does it say that?
I'm just finding the paragraph. Oh, here we are, paragraph 22. That's core bundle, page 92, tab 8. Any damage to the cargo caused either by wastage in bulk or weight or any other loss or damage arising from inherent defect, quality or vice of the goods, or any other cause arising without actual fault or privity of the carrier.
Sorry, you've got ahead of me. Where do we find this?
Paragraph 22 of the original defence, it will be struck through in the amended defence.
You know, right, I see, yes.
So which page did you say?
Page 92 of the core bundle, my lord. In cases of assistance, the reference for just a confirmation of the implied warranty is at Benjamin Sales of Goods, paragraph 19-182, which is tab 9, page 204 of the authorities bundle.
Yes, but that would have been overridden by the certificate of unloading.
It would be very difficult to argue that it's still there when you have express clauses of a specification and a term saying seller do not guarantee any other specifications not set out in the contract. However, the point is a dispute could exist whilst we would say it wouldn't be successful, shouldn't be successful, it could be successful. And one of the points we have to bear in mind is that if we're going to open up every settlement sum to an assessment in some form of mini trial as to whether or not the claimant or the purported claimant within that dispute would have been successful, and then the necessary secondary question, would they have been successful to the level of the settlement dispute? Otherwise, the settlement is not going to be collateral and will be included. We'll create not only massive amounts of work for the court, but a massive amount of commercial uncertainty. The number of cases that come before the commercial court where the claimant has received a payment, for instance, by its insurer under an insurance policy, which currently everyone accepts to be collateral, would, on that analysis, in my submission, require an assessment of whether or not the insurer could avoid that policy in order to assess whether or not they actually had the rights under that to bring their claim against their insurer, whether they actually could have brought that dispute. Otherwise, it's just a payment by an insurer, which brings us into a gift question. But if any settlement sum is open to a mini trial as to the merits of said settlement, that, in my submission, is neither good for commercial certainty nor the purpose of the courts.
Well, I don't think at the moment, for myself, I don't think I'm sort of worried about the merits of the settlement. I'm just worried about whether there was a dispute in the first place. Or what evidence, sorry, put it more accurately, what sort of evidence we actually have, barring the two very thin references you've given us in the judgment.
We have the two references in the judgment. We have, in my submission, the logical conclusion from the steps that have been taken. We also have the signed affidavit of Patrick Holloway, where he says at paragraph 13, that's supplemental bundle, tab 7, pages 22.
Yeah, well, this is the one I was putting to Mr. Seaman.
Yes, but it's a slightly different point in that it says, in consequence of the events described below, which resulted in Oilex rejecting a portion of the consignment, on the basis that it was damaged and not fit for purpose.
Forgive me, I shall now betray my ignorance of shipping law technicalities. Clearly, qua owner.
Yeah.
You can. You have. Sorry. Clearly, qua buyer, you can reject the goods. Mm-hmm. You have sort of a locus to do so. Is there an equivalent concept for a bill of lading holder, which Oilex was treated as being?
My submission is that the use of the word reject there is somewhat non-technical. They're saying these goods are bad and this raising of a dispute. It's not, and nor was there any factual finding that the goods were actually rejected, which is why we refer to them as a purported rejection, similar to the Baltic Strait where there was a purported rejection of the goods, but it didn't actually occur, and therefore the title to sue sat with the bill of lading holder.
Yeah.
Or in that case, it was found alternatively to have settled, and therefore title to sue still sat with bill of lading holder. Insofar as there wasn't a commercial dispute giving rise to the settlement sum, then in my submission, the only possible explanation for the steps would be something equivalent to benevolence or a gift from sellers to owners. So, sorry, from Ameropa to Oilex. And in my submission, this is likely the reason why the trial judge found at C562 in their reasons for rejecting the permission to appeal. Oh, sorry, apologies, it's in their judgment. That the owner's criticism of the merits of the commercial settlement reached between the first claimant and Oilex would not affect title to sue or give rise to a credit in the owner's favour.
So, page 62, paragraph.
Let me just get it up. Apologies.
You were quoting from 45.
Thank you.
Paragraph 45. Indeed, the last 3 lines of paragraph 45. Apologies, I didn't have the paragraph in my note.
So can you explain to me the sentence beginning the arrangement concluded? What's the distinction the judge is trying to draw there?
That's the settlement sum.
So she's saying is this right? The arrangement concluded between the first claimant and Oilex on around the 24th of September 2020. So it was directly linked to rights under the existing sale contract rather than arising out of the breach by the owners of.
Yes, so that's paragraph 46.
Yeah,
it's a sales contract rather than arising out of the breach by the owners of the contract of carriage.
She is effectively accepting the distinction drawn by Mr. Seamark between a payment which arises out of the contract which has been broken and the sale contract, which is an independent transaction. And she's saying it falls on the independent transaction side of the line, and that's why Mr. Seamark says that that paragraph is wrong, or that statement is wrong.
She's certainly saying it is unconnected to the breach in that it is an independent source. It arises from an independent cause, i.e. via Swinson. Now, if it was not a settlement and therefore it was simply a gift, in my submission it would be on all fours with what Lord Mance says in Swinson at paragraph 48, which is tab 6, page 142 of the authorities bundle, where he says, if Mr. Hunt had simply given Swinson the amounts of the outstanding 2006 and 2007 loans, no one could have suggested that HMT could have benefited from this, i.e. it would be a gift.
Sorry, which paragraph did you say?
Paragraph 48. And then later at the very end of paragraph.
Hang on one second.
Apologies, go ahead.
Yeah.
Later, at the end of paragraph 49, again, however, there is all the difference between a benevolent act which benefits a claimant, here Swinson, collaterally in an amount equivalent to a loss which it has incurred, and satisfaction of the claimant, Swinson's loss by Mr. Hunt. Funding of EMSL to repay Swinson. The claimant's loss in that case obviously being the lack of repayment of the loans lent to EMSL. Similarly, in this case, the claimant's loss is having received cargo worth less than it would have if it had received cargo in good condition, although assessed by the proxy of CIF value to assess sound market value and salvage sale to assess damage market value. If it was not a settlement under a claim under the sales contract, the only other explanation is that it's some benevolence. But it doesn't satisfy that loss. So it's still, by hook or by crook, to pardon my informal language, still collateral. Lord Newberger makes a similar point at paragraph 99 for your reference, initially saying it's not appropriate to look more widely about the payments to EMSL, but, quote, even if it is appropriate to look more widely, a new loan was not a gift, but a short-term repayable loan, albeit carrying no interest. To summarise the points on the CIF distinction, then, my lords. One, the respondent says that the judge found, as a fact, that there was a purported rejection and a settlement thereof. Two, insofar as you're against me on that, the only commercial inference one could reasonably draw is that there was some form of dispute which was then settled, which, as I say, is consistent with the evidence of Mr. Holloway. And three, insofar as it wasn't a commercial dispute, the only other explanation is benevolence.
Sorry, your fallback position is that there was it can be inferred there was a dispute. What was your primary position?
My primary position is the two quotes I gave you from the trial judge established at the finding of fact that there was.
Oh, I see. So really right.
Now that might well be an inference as well.
Yes, I see. But it's two ways the same route. That there was a dispute, either because the judge has so found, or because it's the only common sense inference.
Yes, my lord.
What was the status at the trial of the affidavit of Mr. Holloway? Was it evidence of what had been said in South Africa in order to obtain the arrest of the vessel, or was it evidence of the truth of its contents?
Its status was to rebut an allegation which has been made once again at the appellate level by the appellants that dating of the assignment was done deliberately in order to somehow mislead the appellants, then the defendant. So, therefore, the truth of its contents, I suppose. Because the point was made that originally references were made to dishonest steps. At this stage, only a reference was made to the attempt to create rights in some manner of the 7 September dating, and that it was done in order to mislead. Now, we adduced the affidavit and relied on that for the purposes of saying, well, no, he tells you in the affidavit that the written version of the assignment is going to be produced. So how could it possibly be used to mislead?
Mr. Holloway's affidavit is multiple hearsay, although sometimes that's not a bar to admissibility in the civil courts. But just to push a bit further on the strict question, I'm afraid I can't remember what the default rule is in the business and property courts, but if a document goes in the bundle, is it automatically evidence of the truth of its contents unless there is some stipulation to the contrary? Or is
My understanding is that there has to be an objection.
Could you chase
Well,
that? Could you chase that for me?
I can chase that for you.
I think actually I had that hearing last week. I think the principle is that the mere fact it's in the bundle does not mean it's in evidence.
Right. Well, in that case,
I think that was in the commercial court.
I'll defer to my lord's.
That certainly used to be the rule.
I'll defer to my lord's recollection of my own.
Well, no, we don't want you to.
No, definitely. That's very, very ill-advised on
and it
even
may
from
not.
last week.
And it may not be simply whether it's in the bundle or not. It may be whether it's referred to at the trial. I don't know. Could you find out what the rule is and tell us? Preferably agreed, but if not agreed, then you'd better each tell us what you think the position is as to the status of that as evidence.
I will do, my lord. Thank you. Now, that's, unless my lords have any further points on it, the CIF distinguishing factor, alleged distinguishing factor. I was then going to move on to what I have termed the construction argument. The assignment of rights is at Supplemental Bundle, tab 8, page 39.
Well, we didn't hear anything about this from Mr. Seaman.
It may be that...
Who accepted, as I understood it, that if Oilex had a claim, as at the date of the assignment, that the assignment was effective to assign it to Ameropa. His point was that Oilex had already been made whole and therefore subject to the 9,000, and therefore there was nothing of any value over the 9,000 to assign.
My understanding, my lord, at least from the skeleton argument, is that he has two separate points. Point one is that the wording of the assignment was not effective to assign what he refers to as the representative claim. Now that might well be dropped now. And then point two was the timing of the assignment, which I also understood is now common ground that insofar as the payment is collateral, then the assignment stood good at.
Yeah, I think you're certainly right that when gently pressed, he accepted that it really didn't go anywhere, the timing of the assignment point. So I don't think you need to address us on that. My lord, I noticed that there was no development in his oral submissions of a separate argument about simply about the wording of the assignment. I'm afraid I hadn't focused on it till you mentioned, but it looked to me as though that wasn't being pursued. It's not being pursued as a separate point, is it, Mr. Seamark?
The point is simply, as said in my settlement argument, that the wording is rights pertaining to us. That meant, on its proper construction, Oilex's own rights to sue the owners. It wasn't effective to transfer a representative claim, but nothing turns on it because the judge found awarded damages on the basis of Oilex's own loss that it did suffer.
Yes, quite.
Yes.
Well, I don't think anything does turn on that point either.
I'm grateful.
So that you can cut another swathe through your notes.
Just on the timing point, so in my submission, one aspect of the timing assignment might still be relevant. And it's not the timing of the assignment, the written assignment per se. It's the point that my lord made earlier and it comes back to a similar point as to Mr. Holloway's statement and its evidential value. If the statements made by Mr. Holloway are correct, that the credit note was given as tit for tat for an eventual assignment, with the mechanics of that assignment being the written assignment that eventually occurred. My learned friend submitted, well, that's not relevant because written assignments are only effective once written under the Law of Property Act. In my submission, that's not quite the point. The point is the characterisation of what my learned friend calls the 24 September agreement, and whether or not, if he is right to rely upon ED&F, and we'll come to that in a little bit, if he is right to rely upon the idea of one transaction, then it would come within the reorganisation of rights of pursuit rather than a simple settlement, similarly to the ANZ settlement in the ED&F case. But I'll come on to how applicable that analysis is. My learned friend seeks to rely upon ED&F to say that, similarly to the statement at paragraph 62 of that claim, where if the settlement agreement had done no more than settle ANZ's claim, that's page 185, tab 7 of the authorities bundle.
Which page did you say, sorry?
185, my lord.
Thank you very much.
There it is held by my lord that if the settlement had done no more than settle ANZ's claim for US $291 million for a less sum of X million, I would have accepted that submission, namely the submission that they had avoided their loss. Now, what one has to bear in mind when looking at that conclusion, and the latter conclusion that because it had additional elements and was a much more complicated settlement, which also provided for deductions as and when ED&F managed to claim sums back from Straits, that it was then not avoiding the loss, is that all takes place within the context of a deceit claim, or an unlawful means conspiracy claim where the unlawful means utilised was deceit. And within that context, and when assessing damages on the deceit analysis, one has to look at all of the benefits received from the transaction into which one was deceived into entering. And in that case, it was found that ED&F's loss was its liability to ANZ, so that the settlement of that liability settled the very loss, which is once again similar to Swinson, where the payment of money to EMSL, which was then paid to Swinson, was avoiding that very loss that Swinson was claiming from the defendant. That's not the case here. So we've dealt with what is alleged to distinguish this case from the Baltic Strait, the Sanix Ace, and RW and Paul, which, as my lady friend notes, has stood for some 100 years. There's also a suggestion that at least the Baltic Strait is not consistent with Swinson, because rather than looking at the actual independence of the payment, we're just making a blanket rule. So rather than looking at whether or not the payment arose independently of the circumstances giving rise to the loss, my learned friend says that the Baltic Strait just makes a blanket rule for bills of lading cases where a settlement is being received from a seller. In my submission, that's entirely consistent with the blanket rule we have with insurance payments, with the blanket rule we have with pension payments. There's a reason for the rule, which is my Lord Sumption's point of just reasonableness and fairness being the reason for the principles we've applied, not having to be assessed in each individual situation. The reason we have this rule is because settlements under sales contracts are by their nature independent from the breaches of a contract of carriage. That settlement is a settlement under a separate transaction. It's a settlement which, whilst is paid because something has happened, does not arise from that action. It arises from the relationship between the seller and the buyer, in the same way as the insurance payment arises from the relationship between the insured and the insurer. So in my submission, not only is the Baltic Strait right, it is on all fours with this case. One has to bear in mind that similarly to this case, the effective claimant in the Baltic Strait was the assignee. The assignment was done, as we can see if we turn to tab 5. On the first page, left-hand column, about halfway down, in due course, Comica agreed a credit of £2,586,105.
Sorry, I'm behind you. But we're
Apologies.
Straight, which page?
Tab 5, the first page of the judgment, page 33.
Thank you. Yeah.
In due course, Comica agreed a credit of $2,586,105.09 in favour of Alfadol. Subsequently, Alfadol assigned its rights under the bills of lading to Comica, and Comica assigned Alfadol's rights under the bills of lading to cargo insurers, SEAT, and then SEAT pursued the claim. So there, as here, we have a purported rejection resulting in a settlement and a subsequent assignment with the assignee pursuing the claim which it was entitled to do. Now, my learned friend has pointed to certain representative elements of these judgments that he says have arisen. In my submission, there's no separate either title or category which is relevant of a representative action. All these cases are cases where the parties have received a payment which is collateral. They happen to have received that payment due to the split between risk and ownership. But that's not the reason why those payments are collateral. The reason they are collateral is because they arise under a settlement from a sales contract or a finding of liability at arbitration under a sales contract. And indeed, I point you to the passage my learned friend already raised from R.W. and Paul, where it says that the mere fact that, I'll take you to that point. It's tab 1, page 8, which which is page 33 of the judgment, column 1. It would only, so in this respect, I do not think that Mr. McCatter, for the ship owner, has seriously contended that the fact that Messrs. Paul have been compensated by Messrs. Broster, who were merely intermediate purchasers, rarely affected the question at all, i.e. the question of title to sue. It would only affect the ultimate destination of the damages, because I have no doubt that Messrs. Paul would have to account. And then earlier in the same judgment at page 30, which is page 5 of the authorities bundle. I do not think that that matter, i.e. the payment by Broster to Paul, affects the plaintiff's right to sue at all. If they have a right to sue the ship, what they have to do with the damages by reason of some other transaction they may have entered into does not seem to affect the case at all. One more point in support of the trial judgment is Parry and Cleaver, if I can take you to the judgment of Lord Reed at tab 2, page 29, which is page 20 of the judgment.
So which page?
Sorry, apologies. Page 29 of the authorities bundle, page 20 of the judgment. Parry and Cleaver, as we discussed earlier, is a case involving a policeman who was injured, therefore had to leave the force, work a civilian job, but was entitled to a disability pension. The question in the case was, one, whether the disability pension had to be taken into account when assessing the loss of earnings that the policeman had suffered, and two, at what stage it had to be taken into account, because the period was split into separate stages, dealing one with the period when he was just earning the civilian wage, and then two with a period where he would in any event have been retired from the police and therefore earning the full retirement pension. In this paragraph, Lord Reed states, it has been asked why his ill health pension is to be brought into account at this point.
Which paragraph do you referring to?
Apologies, I will get it up for you.
Just at 29H. Page 29 of the bundle, just at 8.
Okay, right at the bottom of the page. Yeah, I've got it now. Thank you, my lord.
So we're talking about his loss here after reaching retirement age. It has been asked why his ill health pension is to be brought into account at this point, if not brought into account for the earlier period. The answer is that the earlier period we are not comparing like with like. He lost wages, but he gained something different in kind, a pension. But with regard to the period after retirement, we are comparing like with like. Both the ill health pension and the full retirement pension are the products of the same insurance scheme. His loss in the latter period is caused by his having been deprived of the opportunity to continue in insurance, so as to swell the ultimate product of that insurance from an ill health to a retirement pension. There is no question as regards that period of loss of one kind and gain of a different kind. So that's similar to Swinson, where they did the same like for like analysis of this is a payment actually of the loss suffered, rather than a collateral payment, whether it be a gift or loan directly to Swinson from Mr. Hunt. Similarly, in this case, the loss suffered is the reduction value of the cargo delivered damage, and the payment made by Ameropa does not satisfy that loss. It is of a different kind. So in my submission, it's consistent with Parry and Cleaver, Baltic Strait, Sanix Ace, and has not been in any way reduced or rendered in need of reassessment via ED&F or Swinson. And in my submission, the trial judgment should stand, unless you've got any other questions subject to the point about the evidential value of Mr. Holloway's witness statement.
You've given us Scrutton. You've given us Scrutton. Do the other leading textbooks, Aikins, Cook and Young, and so forth, have anything to say about the Baltic Strait?
I don't have the references to hand, but I can readily assume that if they said anything negative, my learned friend would have brought it up in his usual style.
I was thinking you might be interested to find out if they say anything positive for you.
Indeed, I may. And if we're going to have to deal with the Holloway point anyway.
If you've not looked, then you've not looked. Never mind.
What I will say is that all of the previous judgments within the Baltic Strait, you have a list of previous textbooks which support the Sanix Ace and R.W. Paul, and one would assume that they also support the Hobhouse, Mr. Justice Hobhouse's reasoning in the Baltic Strait insofar as he saw it when writing that judgment. Otherwise, he wouldn't have included it. Pardon?
You mean in the Sanix?
I do indeed. Apologies.
Or you mean Mr. Justice Andrew Baker?
I just made two mistakes. That was impressive. I mean Mr. Justice Andrew Baker, and I do mean the Baltic Strait. Apologies, but...
Now, yeah. I thought what you were saying is that in Mr. Justice Andrew Baker's judgment, there's reference to lots of textbooks.
That is what I'm saying.
Yes. And they are presumably, therefore, supporting the analysis up to that point.
Indeed. And at least what he must see as his own analysis.
What we don't know is what may have been said since his judgment.
Indeed. If I'm going to come back either on a joint basis for the Mr. Holloway point anyway, I'm sure my learned friend and I can hand up a couple of pages of things dealing with the Baltic Strait.
Well, if there is anything out there that has a bearing, then it might be nice to know about it.
Do my lords have any other questions?
I don't. No, we don't. Yes, Mr. Seamark.
Thank you, my lord. Bulk of my learned friend's submissions focus on what he says was a settlement agreement between Oilex and Ameropa, which he contends arose out of the sale contract. The first point to make is that calling it a settlement agreement is something of a misnomer. Not only is there no correspondence before you indicating that any rights were asserted under the contract, or indeed that there was ever any dispute under the contract to settle. But unlike any other settlement agreement I've ever seen, Oilex was made completely whole for the entire purchase price of the cargo. If this was genuinely a action taken to settle the claim which had been made under the sale contract, one would have expected some form of discount to be applied.
I don't understand the second point. Well, the settlement agreement, if someone feels they have no defence, should be then to pay out the whole amount.
Yes.
So all the term is...
Yes. But the point is, if the case my learned friend is arguing is that this is properly understood, the payment is properly understood as a settlement agreement of a dispute under the sale contract, as your lordships put to my learned friend,
there is no extant right under the sale contract for Oilex to receive anything at all from Ameropa, let alone reimbursement for the full value of its loss. The point is that they recovered $355 from the salvage sale, and then the $284,000 payment made them substantially whole for the entire sum that they had paid for those 3,000.
I just don't see why that means it can't be called a settlement agreement.
Well, it's, I don't want to put it any higher. Yes, of course, I suppose it's possible to envisage a settlement agreement of 100% of the loss if there was no defence to a claim. My point is, if it's been put that this is a claim which arises under the sale contract, then it would be a funny sort of settlement agreement that settled 100% of the claim in circumstances where there was no contractual liability to pay a penny. The point is simply this, that it does raise the question, well, what else was that payment for? And my learned friend says, oh, well, it must have been, the only other alternative is that it must have been wholly gratuitous. But again, commercial organisations are not in the habit of making gratuitous payments. My submission to you is that the inference you can draw from the correspondence that we have is that on the 24th of September, Ameropa wrote to Oilex and said, we've agreed a sale at $355 to a sale buyer. Once you've received those payments, authorise the release of the cargo. We then have a letter from Ameropa that same day saying, we've received the sale contracts, we authorise the release, please pay the difference. My submission to you is that that payment, the obvious conclusion to draw from the limited facts that we have is that payment must have been consideration for securing Ameropa's agreement to the salvage sale. Why would that agreement be needed? Because any salvage buyer wants to take the title. They want the comfort of knowing that no other buyer in Egypt is going to come along and assert title to these goods later.
So you said consideration for securing Ameropa's agreement.
Sorry, I meant Oilex's agreement to the release of the cargo to the salvage buyer from the warehouse. And there was no conceivable, that explains why the amount makes Ameropa completely whole for the amount it paid for the cargo. Because there was no conceivable basis on which it could object to that release in circumstances where it stood to make a full recovery, both from the salvage sale and from the additional payment Ameropa had made. And that really just backs up the point that properly analysed, that payment was a payment made in order to secure Ameropa's consent to the release, and it was a payment, therefore, which arose out of my client's breach of the contract and not under the contract of sale. Now, my learned friend took you to the judge's reasons for refusing leave to appeal. If we can pick up at page 75, clause 12 he took you to, saying in particular the Baltic Strait is only applicable where the bill of lading holder is bringing a representative action arising out of physical damage. It suggests that the principle applicable requires the holder of the bill of lading to establish a legal entitlement to any sums settled under the sale contract, which is contrary to the approach in the Baltic Strait. That's not my case. It's not my case to you that losses recovered from a seller are only not to be taken into account if there's a legal right established. The question is simply one of causation. Was the effective cause of this payment Ameropa made to Oilex a right and to settle a dispute which had been asserted under the sale contract, as to which there is no evidence, or is it more likely that the effective cause was to secure Ameropa's agreement to the arrangement whereby the cargo would be sold and delivered out of the warehouse to Etihad?
So you keep saying Ameropa, but you do mean Oilex.
I do.
Yes.
I'm slightly dyspraxic, my lord, and I often confuse owners and charterers, buyers and sellers, and in this case I'm confusing Ameropa and Oilex. But for Ameropa, read Oilex in all circumstances. Now, my learned friend sought to justify his submissions to you that this was in fact a settlement of rights under the sale contract, or a dispute which had risen under the sale contract, by picking up various, what my old principal used to call cigarette butts from the judge's judgment. That's I intend no disrespect to the learned trial judge, but it's true that she only refers to it in glancing, and that's not in any sense a criticism of her, because he took you to page 58 of the judgment, page 58 of the core bundle, paragraph 23 of the judgment, where she records that there was no direct evidence from the first claimant or Oilex to explain their actions. But one of the survey reports that Oilex had rejected the cargo taken to El Shruk. Now, she goes on to say, I have to point out, and it was suggested to you that that rejection must have been a right asserted under the sale contract. But if one goes to page 70 in the bundle, paragraph 85b, the judge, you were taken to this passage, 3 weeks had passed, said the judge, since damage to the cargo had been discovered and Oilex appeared to have rejected the cargo. Well, those comments have to be read with what the judge said in paragraph 86, which you find on page 71. Second sentence. Such evidence was not essential to understand the nature of a salvage sale or to decide whether it was reasonable for Oilex to sell promptly without obtaining a certificate of analysis. One of the issues in the case, my lords, was that the subsequent testing that had been done showed that the cargo was actually on specification, despite the allegations that it was damaged. We said that there had been a failure to mitigate by waiting. Obviously, that's no longer an issue. But what's quite clear from 86 is that she regarded that salvage sale as a sale made by Oilex. And similarly, she goes on to say in 91 that if owners had not been breached, Oilex would have received full sale cargo. By reason of owner's breach, they had to sell the rejected cargo at a lower price. So the references to Oilex rejecting the cargo, I think, mean no more than this in this context, that Oilex didn't want to keep it and was happy to sell it to a salvage buyer. Now, it's perfectly understandable why a receiver of damaged cargo might not want to keep it for its own purposes, but that doesn't mean that it's advanced a substantive claim under the sale contract against its seller. And so the hypothesis that there might have been some form of residual liability under the sale contract, either through some form of unapplied term or because the owners had not admitted liability, is simply that. It's an unevidenced hypothesis. And the point is, it would have been very easy for Ameropa to produce evidence, either in the form of a witness statement, explaining, or indeed the full run of correspondence, because it seems quite clear that there were other exchanges between the parties other than those that we have in the bundle, explaining the circumstances and the manner and the consideration that they obtained in exchange for securing Oilex's agreement. And in the absence of that evidence, it is in my submission not appropriate for you to attempt to draw inferences from facts that are not in evidence, in circumstance to fill in a gap which has been created by the claimant's own failure to properly evidence this aspect of its claim. The point is, there was no evidence at trial at all that a claim had been made under the sale contract, and that's very clear from the
have that point.
You have that
made
point.
it more than once. Yep.
And so this is fundamentally different to the facts that were before Mr. Justice Andrew Baker, because there had been a finding of fact by the LMA tribunal in that case that the Comico reimbursement had been made to settle the sale contract. There was a fundamental factual distinction from the present case. My learned friend says, well, of course, there's a danger if you adopt my line of reasoning that all sorts of cases, including insurance policy premiums or recoveries, will be thrown into issue. No, it's always been recognised by the courts in this country that proceeds of insurance contracts are collateral, and there's a very good reason for that, because the insurance contracts
I don't think he meant. I did hear that observation, but I don't think he meant that.
Yes, but the distinction between the facts that we have here and insurance policies, my lord, is simply that the policies are collateral because they're entered into before the breach. Whereas here we have a series of transactions on the 24th of September which were clearly entered into after the breach, and we say, as a matter of causation, directly in reliance to it. My own friend referred you to the observation in Swinson that if Mr. Hunt had simply given the sum of money which had discharged the loan, that wouldn't have had to be brought into account in support of his argument that the benefit we obtained was effectively some sort of benevolent, gratuitous payment, wholly gratuitous. I'm not sure that is the correct reading of Swinson. I think what the judge was saying at paragraph 48 is that the loan was in fact given, the money was in fact advanced to discharge the loan. And my point simply here is that the payment which Ameropa made to Oilex had more or less the same effect, because, as I've said, it made Oilex whole for the cargo damage and enabled the transaction that had been agreed to on the 24th of September to proceed. As to Mr. Holloway's statement, my understanding, again, my learned friend, I prefer I don't have FIPS on evidence friendly. My understanding of the position is that unless specifically challenged, documents which go into bundles of evidence are assumed to be genuine, i.e. not forgeries, but there's no admission as to the truth of their contents. That's always a matter for weight and rebuttal.
Certainly the rule when I was young, but it might have changed.
I think
Found the rule if it assists.
J 8.5 and 8.6. Or maybe not. Maybe you've got something different.
The one I found was CPR Part 32, Practice Direction 27.2. All documents
Hang
contain.
on 1 second. CPR
Part 32.
PD 32.
Yes. Paragraph 27.2. All documents contained in bundles which have been agreed for use in a hearing shall be admissible at that hearing as evidence of their contents, unless the court orders otherwise or a party gives written notice of objection to the admissibility of particular.
As evidence of their contents. What does that mean?
Well,
I think actually the bit that I knew was that it's in the Commercial Court Guide, J 8.5 and 8.6. J 8.5 essentially says what you've just said, which is the documents in the trial bundle are admissible as the evidence of the truth of their contents, except for documents that are subject of a timely notice to prove authenticity. But then it goes on. The fact that documents in the trial bundle are admissible in evidence does not mean that all such documents have been adduced in evidence so as to form part of the evidence in the trial. For that to happen, the parties have to agree that the document in question is to be treated as having been put in evidence by one or other of them, etc., etc. So, if things go into a bundle, my understanding is that they are to be treated as admissible.
yeah.
They're not actually in evidence unless or until by the mere fact that they're put into the bundles, unless or until the parties agree that they are to be treated as having been put in evidence.
If it assists, it was referred to in my skeleton argument. I'm not saying that's an agreement, but it was expressly referred to.
I mean, I'm working off the 2022 White Book that I just found.
Do you mean to a certain argument below?
Yes. In my skeleton argument below, I made the point that I raised earlier. And
Yes, I'm not saying that Mr. Holloway's statement is not admissible in evidence, but it is, as Lord Justice Mayles pointed out, triple if not quadruple hearsay, and therefore it goes to weight. The other point is, of course, he was giving that statement in July 2021 in order to secure the arrest, and that's well after the 24th of the 9th 2020 agreement, to which, of course, he had no authority. So all we can say from his statements is that he was told, but it's certainly not proof, certainly not evidence of what in fact transpired on that date.
Well, surely, you're saying it is evidence, you're saying it's not very strong evidence.
Exactly.
Yes, right.
Exactly. But if that's the basis on which my learned friend has to make a case, then I'm afraid he doesn't come up to proof. He would have, the best evidence would have been Ameropa, who was the claimant, the assignee, and in a position to tell the trial court, exactly what had happened. And the point came up. And
you do have that point.
Indeed, you do. So, yes, and at the risk of belabouring it, the fundamental issue is that neither Ameropa nor Oilex have ever explained the nature of the 24th of September transaction, and so they must take the consequences. And they had every opportunity to do otherwise.
You should learn to take a hint, Mr.
Yes, indeed.
Mr. Seaman. Reply is only about reply, not about.
I'm going to finish up with. That's all I'm going to say about the evidence. As to the case law, R&W Paul, the Baltic Strait, and the Senex case, I think you have my case on that from this morning. There are only. Perhaps if you'll permit me to trespass on you, I'd just like to repeat my three propositions as to why I say this appeal should succeed. The first is factual. The net loss rule should be excluded where the relevant seller's recovery stemmed from an independent transaction. We say there was no basis.
Repeating something you said again.
I
need to take a note of it. But, yeah.
Indeed. Well, in that basis, hint taken, my lord. That's all I have to say.
I don't know, my lord, feel deprived.
Well, I think I managed to take a note of it first time around.
Thank you both for your submissions. We will be reserving our judgments. Judgments will be circulated in draft in due course for the purpose of the primary purpose of the parties agreeing consequential matters, or if they can't, submitting brief written submissions so that we can decide those at the time of hand down. And also, of course, drawing our attention to any typographical or other minor factual errors. Those are the purposes for which the drafts have been sent. They should not be used for any other purpose and therefore not be circulated wider than was necessary for those purposes. If you want any further help, look at the Counsel General for Wales case. Thank you.
Sorry, my lord, before you... if I understand Lord Justice Nell's suggestion, you would be assisted by any other commentary in any of the other texts on Baltic Strait, or...
yes.
No objection to conferring with my learned friend.
Yes, if you could simply, let's have anything, if there is anything. Thank you.
Court rise occasion.